Can you all see that?
Yes, we can see it.
Let's go to the slide format then. So again, what we're talking about today is reducing risk in contracts. And by way of kind of a backdrop and a preamble to our more in-depth discussion of specific provisions, just to remind you that the contract, and you all know this, is one of the most basic of human relationships. It's a means to assure stability and predictability in both our personal and commercial transactions. And I'm a little older fella. I'm not going to tell you how many years older, but I can remember a day when handshakes and things were a little more common, and those are still good and important. But the written word, the contract, is the document that is often cited and used in court, and it provides that stability that we all need in our relationships with others. So interpretation of contracts often, I wouldn't say that we get too many, but may lead to litigation. One, because of ambiguity often arises because the contracts are poorly worded. Secondly, the parties can interpret each contract differently. Absent some evidence of misrepresentation, the courts try to stay away from rewriting the courts or the contracts, in Montana included. And if the contract isn't clear, the courts will often determine the parties' intentions by reviewing the terms of the contract, or in some instances, the surrounding circumstances, including emails, phone messages, and/or other discoverable information. So be careful what you put in the contract and what you write. Be clear about what you write and what you put in contracts, including correspondence, voice messages, and communications, because the courts sometimes have to go that far into that kind of depth to figure out what really happened and what the parties meant. Risk management, that's who we are, where we come in. What we're attempting to do with risk management is establish programs, processes, and policies to mitigate losses. It's good for our agencies and universities. It reduces the cost of insurance, and we're able to achieve this through contractual risk transfer in agreements between parties. Wanted to kind of put together this overview of contractual transfer as a risk management tool. If you look at risk as being an act or an activity or an asset of the state that can prevent an organization from achieving its objectives, there are three branches on the tree. We attempt, first of all, the finance risk through insurance, and we administer 26 commercial insurance programs in behalf of your agencies and universities, or transfer the risk, get others to take it on. We hire independent contractors. That's where you come in. You deal with a lot of contracts, and I'm sure I have some interesting stories to tell about how those played out. Second branch on the tree is to control. We attempt to mitigate risk by controlling it through prevention. We have loss prevention programs that we have instituted and put in place to mitigate and reduce the footprint on our litigation and on our claims. And then finally, claims management. We have dedicated attorneys and claims professionals who are here in case things go south to put on a legal defense, to look at the contracts, to look at what went wrong, and to put up a defense, and to kind of figure out how to manage all that and how to resolve it all. Why transfer risk? That's the burning question that you're probably all here today to hear me, the state's risk manager and chief risk guy, tell you about. I think first and very importantly, you should all know that we're self-insured, that most of the losses are paid from the self-insurance fund. And what that means in a very real sense is that every biennium, the legislature approves funding. We collect money through our proprietary fund from your agencies and use those funds to pay claims and litigation because we are self-insured. We can't get commercial insurance. That stopped in the early 70s with a liability crisis. So those funds are taxpayer dollars. They're our funds. They're your funds, they're the citizens' funds, and we want to do everything we can to mitigate those losses and prevent them. Secondly, the potential loss stemming from performance of the contract is too large to handle. I would imagine you guys entered into some pretty big contracts, and some of those may be multi-million-dollar contracts, or they may be small contracts with a lot of risk. The size of the contract does not, in and of itself, determine how much damages could be in a lawsuit or a claim. So typically, we find people with expertise. We tend to transfer the risk to them because they have that expertise. And that leads us to the contractor. They're often in a better position to control and assimilate the loss. And it's required by law. We cannot insure independent contractors through our fund. Any litigation that they get involved in or losses that they're sued for, they and their insurance carriers have to pay. However, if we don't have appropriate contractual provisions in our contracts in place, that liability can be imputed to the state self-insurance fund. So there are two key contract provisions that we want to focus on and address today. The first, indemnity clause, and second, we'll talk about contractual insurance provisions in contracts. Let's begin with indemnity clauses. One, indemnity clauses, I think you all know what those are. If you don't, ask me or shoot a message to the moderator, but they're also referred to as hold harmless clauses or exculpatory clauses in a contract. They alter the way liability is allocated by showing intent. They differ considerably in the way that they're worded and in the way that they're structured. They clarify and pinpoint accountability. If something goes wrong, if there is a negligent act or omission, who is going to pay this claim? The state or the contractor, or both? Indemnity clauses are typically useless without insurance or some other financial transfer device. That contractor doesn't carry insurance, and it's a multi-million, $100 million claim, how much insurance are they going to have in their corporate profits or reserves without insurance to pay that claim? Chances are they won't have a whole lot of money set aside without insurance. Contracts may not be enforceable in some states with anti-indemnity statutes, and they must be carefully construed.
We have our first question, Brett.
Okay.
What is subrogation and waiver of subrogation? I sometimes get insurances that this is provided. Does it
That's
work
actually
in lieu
an
of additional insurance?
That's actually an excellent question. We're going to talk about that a little bit later in our presentation. If I somehow miss it, will you remind me then? Just the quick lead-in is
Sure
that
thing.
Go ahead.
I said, sure thing.
Yeah. So yeah, we'll get to that, and it's about 5 slides down. It's an important question. So indemnity agreements, we allocate risk among parties to a contract, and secondly, the other purpose, to provide a contractual right to pursue recovery from the other party assuming the liability. So if your independent contractors make bad decisions or go a different direction outside of your contract, and there are damages, tort claims or claims for personal injury or property damage, we want to make sure we have a contractual right to recover from them and their insurance if they're liable. Types of indemnity agreements. Limited form. A limited form indemnity agreement requires the contractor to be responsible for his or own negligence. It'll typically say something like this. The contractor agrees to defend and indemnify the state of Montana from and against any and all claims, blah, 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 arising from his negligence, his or her negligence. Intermediate form requires the contractor to be responsible for his or her own negligence and the joint negligence of the contractee. So it may say something like the contractor agrees to defend and indemnify the state of Montana from and against their negligence and the state's sole negligence for work performed under the contract, meaning that they would pick up their tab for things they did wrong. And if we have kind of some shared liability or responsibility, or even if that liability is sole liability on our part, we ask them to pick it up through their insurance. We want them to defend and indemnify us for theirs and for our negligence. These aren't uncommon. We prefer intermediate form. We like to see those in contracts. Your ability to negotiate them will depend upon your bargaining position and power and the type of contracts. Broad form indemnity provisions require the contractor to be responsible for anything, any and everything, their negligence and our negligence. Those are difficult to get in place, are not very popular, and you would have, I think, a more difficult time imposing a broad form requirement. You're going to have more success with limited or intermediate form in your provisions. And I think the boilerplate that we have put out there is in between limited and intermediate form, for lack of a better way to put it, in terms of the type of indemnity agreement that it is. So it's important in your contracts to spell out the parties' obligations and express the intent of the agreement clearly and unequivocally. We have some specifications, some boilerplate, which we put on our website and we've shared with procurement and worked with them and their task force on. It's been a great partnership, and we're on the same page. And so our recommendations parallel their boilerplate and their language, but we want to be clear. And I want to share with you this case because it's sort of precedential and it illustrates the difficulty that arising from a contract that isn't clear and unambiguous with the indemnity provision in the contract. It's Atlantic Richfield versus Grant Norpack. That actually happened here in the Helena Valley, back when Helena was smaller in our younger and more innocent days, and there weren't as many people. There was actually exploration for minerals that went on out in the valley. In this particular incident, ARCO retained Grant Norpack to conduct seismic testing for a purpose of oil and mineral exploration. So in 1983 and 84, Grant Norpack conducted this testing with explosive shock waves to ascertain the presence of minerals. Apparently, the shock waves caused the chickens to stop laying eggs and affected the people's hearing and other damages. That was more of a rural area at that time. And so there were damages people experienced. Is there a question? No, okay. The plaintiff landowners then sued, contending that the procedure damaged their property. So here's the indemnity agreement. I know these are near and dear to your heart, right, procurement professionals? You see these in your contracts. Our attorneys and agencies use a variety of form, and they're not all the same, but this was the agreement in the ARCO Grant Norpack contract. The contractor shall protect, indemnify, and save the client harmless from and against claims, liabilities, demands, and causes of action and judgments, including the cost of defense and reasonable attorney fees, arising in favor of or asserted by third parties on account of damage to property, personal injury, or death, which injury, death, or damage is the result in whole or in part of the negligent acts or omissions or willful misconduct of the contractor, its employees, agents, or subcontractors. Gasp. I need to catch my breath. That's the indemnity agreement. So the facts were that the plaintiffs, Grant Norpack, sued ARCO for damages, and ARCO incurred $64,000 in attorney's fees in defense cost. Grant Norpack said, yeah, we were negligent. They conceded that they were negligent in doing the testing in the shock waves, and ARCO moved for summary judgment that it was entitled to attorney's fees, the attorney's fees that they incurred in defending the underlying claims, as well as establishing their right to indemnification. So ARCO, basically said, we want not only our attorney's fees for being involved in defending our clients, but we want the attorney's fees associated with us establishing our right to being defended because the hold harmless and indemnity clause wasn't clear. So the issue is, should the indemnity agreement allow ARCO to recover attorney's fees, which were expended to defend against claims of ARCO's own direct negligence? In the conclusion, on appeal, the Supreme Court ruled that ARCO was entitled Grant Norpac conceded negligence. They were entitled to defense costs, which Grant Norpac had to pay, but they weren't entitled to the costs associated with establishing its right to be indemnified because it wasn't in the indemnity provision. And the court further stated that in order to uphold an indemnification agreement for damages caused by negligent acts of the indemnity, there must be clear and unequivocal terms. An examination of that indemnity agreement discloses no ambiguity. In summary, had ARCO established in the agreement that attorney's fees, including our right to establish indemnification payments as part of the settlement, had that been in there, the court might have erred or ruled differently. But because it was not clear or unequivocal, they didn't recover their attorney's fees. They got everything else, the damages and their own attorney's fees, but not the fees associated with defense and seeking to establish that examination. So kind of a good example. A little bit long, but kind of a good example of what happens if the insurance requirements in contracts are weak and or the indemnity provision isn't strong. So let's segue into a discussion of insurance requirements in contracts. They're there, as you all know, to fairly allocate risk and to clearly and concisely delineate the types of levels of coverage. Here are some of the concerns associated with contractual assurance if it's not done right. The contractor purchases coverage which is excess of the state. Have you seen that in your contracts where the contract or will say, our coverage is excess of any other insurance that's available, it isn't primary. So that could be one problem. The contractor's insurance company becomes insolvent if they have insurance with a covered company that is A or best rated C, or it's a bad company, they may not have the money to pay the claims for the contractors. Third, the contractor fails to name the state as an additional insured. So they'll cover their stuff. Their insurance will pick up the tab for their damages. But through no fault of our own, that liability is imputed to you all, to your agencies. Then, and in some cases, unless you're named as an additional insured, then you're going to look to us, or the contractor is going to look to us in our self-insurance fund for damages if the insurance doesn't cover. Fourth bullet on the left side, contractor's insurance excludes supervisory acts of the state. Many commercial general liability policies state that they'll offer additional insured coverage, but not as respects a whole litany of different scenarios, including supervisory acts. What if the
Brett,
contract?
I'm going to interrupt you real quick for a question from Heather Davidson.
Okay, thank you.
Hi. Yeah, this has to do with the additionally insured.
Yes.
So if you have more than one contract with the same contractor, do we have to have them, do they have to be listed on a separate certificate for each contract? Or can they just having one certificate with the state of Montana listed as an additionally insured be sufficient?
I think it would be better to have it listed for each contract. It gives you a little more protection. If there are multiple claims on multiple projects and you have one certificate and you produce the one certificate, that's all good and well. Their projects may not be project specific, or they may be project specific, but it might be better to have a separate certificate, or in the one certificate, you can reference the other contracts that it applies to.
Okay.
I think either or.
Thank you.
Did that answer your question?
Yes, thank you.
You bet. Okay. So moving along the list of concerns, the contractor purchase claims made versus occurrence coverage. Just kind of to give you a quick primer on what that means, liability policies were written on a claims made or an occurrence basis. On a claims made basis, the trigger for the coverage is when the claim was made or filed in court. So if you have a contract that begins on January 1st of 25 and runs through January 1st of 26, Under a claims-made policy, you might get a year or two of tail. If there's something bad that happens during the contract, then a year or two after that claim is filed as a lawsuit in court, these claims made may provide coverage for the current year of the contract or 1 or 2 years after, but it won't be indefinite. It won't be 10 years down the road. What if somebody waits 5 or 10 years and the statute of limitation hasn't told and they filed a claim? Under an occurrence policy, the trigger is the occurrence. If that claim occurred during the period of July 1 of 25 to July 1 of 26, it doesn't matter when the claim is filed. It's covered indefinitely down the road, 5, 10, 15, 20 years. Occurrence is better, but I can tell you that most professional liability policies are written on a claims-made basis. Many occurrence are still written on many general liability policies are still written on an occurrence basis. So occurrence isn't uncommon with general liability policies. Claims made is more common with professional liability policies. And finally, the contractor purchased high deductible insurance. What if they have a $5 million deductible on their insurance? They're funding those losses, and we have no assurance that they're going to be able to pay the claims in that retained layer. We call it a retention or deductible layer before their commercial insurance makes payment on a claim. So developing insurance requirements. First of all, we want to evaluate the risk and determine what level of insurance should be required. Riskier contracts may require you to carry higher insurance. Keep it simple. You want to use the appropriate boilerplate that the procurement division and that our office has put out there and made available. That will make sure that the contractor's insurance agent will understand. They should speak the lingo, and the lingo that we put in our boilerplate is something that they may not agree with, and there may be some go back and forth on that, but it will be lingo that they should relate to and understand. And finally, use our guidelines to establish appropriate boilerplate to mitigate risk and protect your agency from unnecessary liability. So as an example, if you're dealing with a janitorial contract or a facilities management contract with people who are out doing certain things, you'll have to determine if you're going to require $1 million, or maybe you can require 500,000 in insurance, as opposed to if you have a doctor that's consulting at one of our institutions of public health and they're on contract to treat patients at our institutions. The level of that risk is kind of quite a bit different than risk that would involve housekeeping or maintenance. And depending on the type of maintenance, that might not be true. But you can see that you want to tag the insurance limit to the level of risk. Number 3, bullet 3, keep it simple. Use appropriate boilerplate and common terminology that they will understand. I've mentioned that already. And then our guidelines. Developing insurance requirements. Here are some other considerations. And you've probably faced these day to day in your contracts. If your insurance requirements are too low and there's a loss from the contractor's negligent acts, there may not be enough insurance protection, and that liability gets imputed to us. If the requirements are too high, the insurers may object. I can't get that much insurance through my insurance agent, or it's going to increase the cost of my insurance. So the insurance requirement should reflect industry practices. We've given you some guidelines, and in the boilerplate that procurement offers, we typically recommend you require a minimum of $1 million per occurrence, $2 million aggregate. In our contracts manual, we have kind of a little matrix, and so does procurement, about what limits to require given the risk. So the requirements should reflect your organization's philosophy about risk. You may be risk averse, and you may want to require higher limits. You want to use current terminology. Special insurance requirements may be imposed on another party, resulting in additional cost, but they can often be buried in the price of the goods and services. So we want to avoid, certainly, I know with the cost of government and taxes, people want to keep their taxes down. And we don't want to have these unfunded mandates and have large and uninsured losses. So we want to make sure we have enough insurance, but not impose onerous requirements on our contractors. And it's sort of a delicate balancing act.
I do have a question for you, Brett. Who can agencies reach out to figure out what the risk might be?
So we have a manual with some guidelines on different types of contracts and what kind of limits you may require. It's on our website, and I'll get to that a little bit later when we go through our specs. Or it's subjective. If you call me and say for this given contract, if it's a cyber, for example, they're holding your data, I'd want to see limits have a pretty good cyber liability limit. But many of these companies that you work with that may be smaller may not be able to get a $10 million cyber liability limit. So, $1 million's better than nothing. It's a slippery slope and kind of tough, and there's no right or wrong answer. Do your best, try to gauge the level of risk, and then tag an insurance requirement appropriately. Call if you have questions. That's my best advice. If what you need you can't find at Procurement's website or at ours, then give us a ring. I'll do our best to help you. Fair enough?
Yes, she says thank you.
Thank you all. You bet. That's just probably the best way to answer it. Courts have interpreted contracts to the detriment of the owner. So if you're writing a contract, and you all do that a fair amount, and you work maybe with your attorneys or your program managers, and the contracts aren't clear and unambiguous, they're often construed to your detriment. So the acceptability of insurers, that's my business. We're in the world of insuring. We have 26 commercial insurance programs put in place for all of you in the universities. So we know a lot about insurance. In your requirements, you want to make sure that your contractors have the appropriate insurance from a good carrier. An insurance policy in bullet number 1 has little value if the insurer is unwilling or cannot pay claims. Secondly, the drafters should include clauses reserving the right to reject coverage written by unacceptable insurers. I know that over the years I've been involved in just a few contracts where there are carriers that were unwilling to write, for example, youth retreats and youth camps. Some of our agencies used to have youth camps, and they wouldn't underwrite, couldn't get coverage from an A+ best rated carrier. They could find coverage from a lower rated carrier, so we had to make an exception if we wanted the contractors to be able to provide the service to that agency. Top right bullet, first approach is to indicate in the contract that the indemnity may reject the contract if upon investigation it discovers that the condition of the insurer is unacceptable. There's been one instance that I can think of where a contract was put in place. The contract or was required to carry workers' comp insurance and did not have it in place. And an employee and a citizen were injured. So that took quite a bit of work with the Montana State Fund, who has an uninsured fund, to work through that when there was no workers' compensation insurance established in the contract and no independent contractor's exemption, just as an example. Additional insured status. We talked briefly about that. The losses are paid out under the contractor's insurance policy, typically on behalf of the contractor or named insureds. Other entities, so the contractor is the named insured. The policy is in their name. They are the named insured. Other entities may be named as an additional insured. That's usually done by means of an endorsement. An endorsement, folks, is an insurance term for a modification to the coverage, to the policy. It modifies the insurance policy. It's part of the insurance contract and generally legally accepted. So specific provisions, additional insured. In lease agreements, it's better, again, to be specific what you want to be named as in a contract. And I'm not in any way trying to be a smart aleck or facetious about this, but if you request to be named as an additional insured as respect nuclear war or you were being asked to do that, it's not going to cover lease agreements, access, use, sidetracks, and other things. So you'd want to be named on that contract if it's a lease agreement as respects access, use, sidetracks, and easements. That comes into play with the railroads and some of our easements where we have properties adjacent to railroads where owned by Montana Rail Link or Burlington Northern Santa Fe or utility companies such as Northwestern Energy. Vehicle use, named as an additional insured as respects vehicles owned, leased, or borrowed. And finally, general liability, we want to be named as additional insured as respects premises owned, leased, products, contractor supervision, and completed operations. By having that general supervision in there and some of this specific language, we circumvent the problems that may arise with ambiguity if it ends up in court, as was the case in the example we went through with ARCO and Grant Norpac. Reasons for seeking additional insured status: to avoid problems associated with unenforceable contract. First, so it isn't left to the courts. It's specific and it leads to a better interpretation and a better result. Secondly, to obtain the same rights to defense cost coverage as the insured under the contractor's contractual liability coverage. Top of the right, third bullet, to avoid subrogation. Someone asked about that earlier. If you are named as an insured on a contractor's insurance policy and something goes wrong, there's negligence, there's damages, there's personal injury, they can't subrogate. That means pursue a legal action or go after you because you're a named insured, you're an additional insured on their own policy. They can subrogate against external parties or third parties, but it blocks them from subrogating against you. And while I'm kind of on this point, a subrogation, what that is it's a strategy to recover money that we are owned or owed as a result of damage caused by a third party. To give you an example, in some of our state facilities, there have been claims where water pipes burst because they were improperly installed. So our insurance carrier will pay those claims to get the damage cleaned up, to get the university back in operation. And because they're negligent, then either we or our insurance carrier will subrogate against the contractor for their negligence in failing to appropriately install a sprinkler line, for example, or a fire suppression system. So it's an attempt to recover damages from someone who owes you a duty and failed in that duty. Does that make sense?
Yes, we do have some more questions about that. Well, back to Rebecca's question, is there ever a moment when there would be a waiver of subrogation?
Yeah. So waivers of subrogation are not uncommon in contracts. And your ability to get a waiver or to exempt a waiver is going to depend on the contract and on your bargaining position. To give you an example, the ski team at one of our universities skis up at a resort, and the resort said, you need to carry insurance and provide us with a policy, and we want a waiver. We want a guarantee that if we're sued because your students on the ski team are up here suing, that your carrier and you will agree not to go after us if they're hurt. Right?
Good example.
So that's an example of a waiver. And in that situation, we would rather not waive our rights, because what if those students on the ski team were hurt because a tree hadn't been trimmed or there was equipment left in the snow that is now covered? But again, in that particular situation, the ski resort saying, oh, nope, if you want to come ski, we want a waiver of liability. So the bargaining position can come into play on the waivers. And it's better if we don't enter into the waivers of liability, because that limits our ability, if they're negligent, to go after them, or for our insurance carriers to go after them if they're negligent. But it isn't uncommon, and a lot of the time we have to acquiesce if we want the contract to move forward.
Great. We have another question based on that. I've seen additionally insured column and the subrogation waived columns both checked all the way down a COI with the state certificate holder. What does that mean?
Could you repeat the question, please?
Sure. I've seen the additionally insured column and the subrogation waived columns both checked all the way down a COI with the state as the certificate holder. What does this mean?
It means, so if the boxes in a certificate are checked, additional insured, there should be a description additional insured as respects what. If the waiver box is checked, I've never seen that actually on a certificate of insurance. Most contractors, their insurance carriers use an accord certificate. But if the waiver box is checked, it means that you may be waiving your right. There's a waiver of liability. You may be waiving your right to go after the carrier, or we're waiving our right, is what I assume. I haven't yet seen that. That's a new one. You've stumped me.
All right, Charles, do you have a follow-up on that? But you can always reach out to, you may have stumbled upon an important issue.
I don't have anything else. Thank you.
Thank you. All right, we're ready to move on.
Okay. So I'm going to, at this point, go to our specifications, and those are found on our website. You may be familiar with them. The Risk Management and Tort Defense Division, under Publications, hold harmless provisions and insurance specifications in contract guidelines. This is what the document looks like. We try to keep it up to date. We work with the Procurement Task Force and our insurance consultants and agents in putting this together. We hope it helps you. And I need to move this box. Hold on. There we go. To page 9 of that document, sample specifications for state contracts. So we'll begin with the indemnity provision, and you'll be relieved to know I'm not going to read all these. It's 9 pages long. But I want to point out that these sample specifications should be pretty consistent with what procurement's using. If they're a little different, that's okay. Agencies have different styles. Generally speaking, they ought to be pretty close, though, or you run the risk of getting out there and away from some of the risk management practices we recommend. But this proposed contractual and indemnity agreement on page 9 was developed by some of the attorneys in the group. And there's kind of a couple different ways to look at it. But if you notice, the contractor shall defend and indemnify and hold harmless. That's pretty common. Against any and all claims, causes of action, liabilities, damages, including attorney's fees arising in favor of the contractors or subcontractors, allegedly rising in whole or in part. That means if they're partially negligent or we're partially negligent, we're asking that their insurance pick up the tab and that the contractor provide evidence of the contractual endorsement. That's optional. It may make a lot of work if you have to go down and track down an endorsement. At least get a certificate. Certificates aren't an official legal document, but it's better than, in some cases, and more easily accessible than getting the contractual endorsement. If you can get the endorsement, it's great. Get it. But this particular clause is subject to negotiation. Some of your contractors might not like all the language that is in there. There's a lot of any and all in favor of any and all. And so to make it work and to get the service, recognize that nothing's always set in stone. We have to keep open minds and recognize they have attorneys and they have insurance agents too. And we don't want your contracts to be bogged down or mired in services that you or your citizens need. That's when it causes problems for all of us, because we need to make government accessible. We need to make these contractors and put them in a position to be able to offer services with some wallboards on the type of insurance and indemnity provisions that they require. So required insurance, we talked about that early. For all insurance types, this required insurance, this phrase. For purposes of this contract, the state means the state of Montana or any office, agency, department, commission, instrumentality. What's in some disagreements, what contractors have tried to do is say, just use the state of Montana or just use your agency, hold the harmless Department of Public Health. If this is in the contract, it's clear that you are part of the state and that this is applying to everyone in accordance with our statutes, 29101 sub 7. Again, common terms we want to see in your contracts: primary insurance, any insurance maintained by them is primary. As respects their negligence, any self-insurance maintained by the state shall be excess of their insurance and not contribute. So we're not asking for the world. We're simply saying in a contract, if you're negligent, you're first, you're primary as respects your negligence. Anything above that is our responsibility, but it won't contribute with your primary insurance. Specific requirements for general liability are listed here. Purchase and maintain coverage on a, I don't know if you know what an ISO form is. We reference this form because agents should know. Insurance Services Office Form CG0001. It's a common form that all insurance agents should know, and or its equivalent on an occurrence basis. We talked about occurrence versus claims made. If they cock their heads and say, what? I don't know what that means, then just, it's okay. Just that you have liability, that would tell them what kind of form. And that's, you know, the kind of a standard that they should probably carry minimum. Or its equivalent, we say, on an occurrence basis. Limits no less than $1 million per occurrence and $2 million aggregate. So that's kind of the starting point. And then I've noted, and this is very important, do many of you do contracts with political subdivisions, cities, counties, and school districts? If you do, they are self-insured like we are. And if you go to them and say, we need you to carry or purchase $1 million, $2 million, they'll say, what? We're self-insured. So this particular clause applies to them. That, you know, their statutory caps are $750,000 per claim, 1.5 million per occurrence. So you can't ask them to carry $1 million, $2 million, because they're self-insured like we are, and our limits are set by the legislature at those caps. Additional insured status. State officials, employees are to be covered as additional insureds for, we're being specific, liability arising out of acts performed by the contractor, including materials, parts, or equipment, so on and so forth. So again, we want to be specific.
Oh, Brett, you got muted there somehow. That happens to me all the time. Just need to click unmute. I don't think I can unmute for you. Brett,
now?
Yes, now we can hear you. We're all set.
How long have I been muted?
About 1 minute.
Okay, good. I'm glad okay. We're back in form here.
We're back in good standing.
Good. So we're moving into, we're talking about insurance specifications, and we're talking about auto liability and the form. I don't know if any of you have had problems with the reference to the form, but it's the form that most insurance agents should know. It's a minimum that's at least equivalent to that, and they should know what that form is. Our agents and our consultants helped us craft that. And then again, you're going to ask them to purchase and maintain the coverage, and then note that the limits for political subdivision are prescribed by statute, and you can only require them to carry 750,000, 1.5 million. That's called a tort cap. We're subject to a tort cap set by the legislature too. And then you can make some changes to the language above so that that provision is more palatable for cities, counties, and school districts. Additional insured, you want to be named covered as respects automobiles leased, owned, or borrowed by the contractor. Workers' compensation, I'm going to skip that unless any of you have questions.
No response there. Oh, you're muted again, Brett. You got a wild mute button.
I don't know why we have a runaway mute button here.
That's okay.
I'm back in the action. Someone wants me to, should I end this now? Someone wants me to shut up, I think. Maybe you're all bored and asleep. I hope not.
No,
This
this is good stuff.
Okay, thank you. So going to professional liability, typically it's claims made coverage. And you're going
to. You went mute again. I'm not sure what's happening there. I promise I'm not muting you.
Are you touching your keyboard? Because sometimes that can do it, especially like the space bar, I think can.
I'm not. Can you hear me now?
Yes, sir.
Yeah, I'm trying to stay away from my keyboard, so hopefully that wasn't causing it. Back to the specifications, huh? So yeah, claims made coverage, ask for occurrence coverage. I say here in the note, if it's not available, then allow claims made, but here are the conditions. The retroactive date must be shown in the date of the contract. They must carry tail. So if you can end a contract, they have to have coverage for 3 years after. That's what this statement here is saying, at least 3 years. If it's an occurrence policy, it's covered indefinitely whenever it occurs. If it occurs during the policy period, it's covered 20 years after the fact. If it's claims made, only 3. We want to see them carry at least 3 years of retroactive coverage. So crime covers theft, honesty, employee dishonesty, forgery, alteration, burglary, and theft. If you're dealing with a contract where they're handling your money or doing all that, that's where you would impose this type of a requirement. We have a crime policy that covers all of those things, but we don't want that liability or that fault of theirs to be imputed to our policy. We'd rather see them carry insurance that covers crime and that protects your assets from all of these risks: dishonesty, forgery, alteration, burglary, or theft. Cyber and information security. I suspect that many of you have contracts or some contracts where they're holding private or personal information that if it's released, it's a data breach. That would be a situation where you want to require cyber information security insurance. And that insurance, what it does is if they release the information inadvertently or hackers get into their systems and hack your data, access your data, then their cyber insurance will notify the affected individuals, offer them credit monitoring and business interruption and coverage for any damages that they may incur, including regulatory fines and penalties from the Federal Office of Civil Rights. I hope you all recognize this is a limited time to cover this much material. I'm doing my best. So I hope that this is meaningful. And to skip through it, you'll have to read some of it on your own. For property, I think, again, most of that, the buildings that are state-owned, if you work with leases and or renovations, these are some things to consider, including subcontractors and deductibles and retention. And then finally, you're going to require a certificate insurance from a carrier with the best rating of no less than A-7. That's a pretty good rating from a pretty big company. And that indicates that there's compliance with the required coverages and that the insurance carrier has the financial backing to be able to pay claims on behalf of that negligent contractor if something should occur that's bad. And finally, you reserve the right to require a copy of their insurance policies. They don't like that. And sometimes in your RFPs or your bids, they'll say, let's get rid of that. Well, my thought is there shouldn't be anything to hide. We're pretty clear about what we expect. And if at some point we request a copy to confirm that they put these things in place, I think we're within our right to ask that. That's exactly what this statement says. We reserve the right to require copies of policies at all times. That takes me through the relevant boilerplate in your insurance document. And that leaves us about, 7 to 10 minutes for questions and answers.
Great. I've got a few lined up for you.
Fantastic.
This is from John Mueller. Confusion for us comes in with asking small 3-man janitorial contractors to carry auto insurance on with our cleaning contracts with them.
It's a very valid question, very legitimate. I'm folding up to this manual. I told you the manual we have, we went through page 9 in the contracts, but there's a table here that tells you, I'm going to find right here, construction, housekeeping, what type of insurance to carry. And then there's a matrix that tells you what limits should be, how much to require them to carry. So on page 5, there's kind of a little bit of a table. And this isn't like going to solve all your problems. It tells you what steps to go through to determine insurance requirements. And then it tells you, kind of how much insurance to require. So if you're looking at a janitorial contract, would you consider that to be low, moderate, or high risk?
I'm just going to jump in and say low, but
Yeah.
I don't know.
If they're maintaining the dome on the Capitol and getting up on top of the Capitol, or they have contractors up doing, or let's say that if it's DNRC and you have divers conscripted to go underneath the dams and look for cracks in the dams, those would seem riskier than a janitorial service contract. I would agree that it would be lower risk. But I would also tell you, we recommend $1 million, $2 million to require in your contracts minimum, because it's not that hard to get. That's the most common block of commercial liability insurance that is sold is $1 million, $2 million. If you think it's too high and the firms are balking, then you're within your right to lower that based upon the risks that you and your principals see in the contract.
Yeah.
And I hope that answers your question.
It kind of does, but what about carrying the auto insurance?
Oh, carrying the auto. Are these janitors driving their own cars?
Yes,
Janitors?
typically. Yeah, they would be.
Okay. So yeah, I would tend to agree with you that there's contracts, and I've listed the kind of insurance, but if you have contractors that are transporting your clients, or they're hauling and transporting expensive equipment and things that you own or that are important to you, require the commercial auto. But if they're doing work where the auto risk isn't the primary risk, like janitors, they're driving to and from the Capitol complex, or maybe one of your other facilities contract, I don't really see a need for the commercial auto. First of all, they're not going to have commercial auto, Trenton. They're going to have personal. They're going to have a policy with Farmers or Allstate or Progressive. And that's a personal as opposed to a commercial, which is for businesses with higher limits. If you require $1 million, that contract will have to go out and buy excess personal insurance. It'll cost them money. I'd say that you're well within your right in certain situations in some of those contracts not to require the auto, or to verify that they have personal insurance, that they have personal insurance and a current valid driver's license. To do that at a minimum.
Trenton has his hand raised, and then I'll get to your question, Heather. Go ahead, Trenton.
Yeah, that was just a follow-up. So the way it was explained to me is that an employee of the state is covered by their personal auto, while they're driving back to and from work.
Yes.
But the employee is only considered to be at work, while they're at their office or whatever. Whereas a contractor is considered to be working for the state from the time they leave their doorstep to the time they return from the job site. So if the janitorial employees are driving from their home to the service location and not driving a company vehicle or something, then their personal insurance wouldn't cover them because they're technically driving for business. So their insurance wouldn't cover them for that. Is that accurate, or would you say that's where we have room for discretion?
Just real quick clarification here on the state employee. You're not covered while driving your personal vehicles to and from work. When you get to work, your insurance through our program. If you're out in the travel mode and you're traveling in your own car on behalf of your agency, your own personal insurance should cover you. If not, your agent can offer a business use endorsement or work with your agency, or better yet, drive a state vehicle if you can. Because there's broader coverage. We get that you can't always do that.
Yeah.
So
I meant that
there's
as a comparison.
Legal nuances there that I'll stay away from. But that contractor, if they're driving their personal vehicle to do the work of the state, I don't see why they wouldn't be covered if they're leaving to go do the work of the state in their vehicle. I don't think there's a distinction in their policy. We're not covering them, when they're leaving their home until they get to the job site. I don't know. I'm not aware that that's addressed in any kind of legal precedent or claim. So I don't think it's something that you should worry about that much. If you require them to carry insurance and it's auto, it should cover them while they're doing your work, you know. And
Okay.
if the work involves traveling somewhere for you or transporting somewhere for you or whatever, I don't think that's an issue with the carrier or a court or in terms of a decision for them to do that. And that gets technical. We should probably move on, but that whether there's any real clear-cut answer, it would depend on many different facts and circumstances, but that would be my take.
Perfect. Thank you.
And can you just briefly touch on umbrella insurance?
Yes. So personal insurance, first of all, there's two kinds of insurance, personal and commercial. Personal insurance is the kind of insurance we all buy for our cars and our homes. Commercial insurance is the kind of insurance that applies to businesses, contractors, others who make money and generate revenue and kind of do it for a living. Commercial pilots, contractors, and others, it's commercial. But commercial versus personal insurance, none of you buy umbrella for yourself. Most of you have a policy that provides you with a basic 100,000 or 50,000 liability. If it's your home, you have, your contents are covered through the replacement cost and liability. It covers $250,000, but there's no umbrella. You can ask your agent to get umbrella. They may or may not be able to get it for you on your personal insurance. You can definitely get it on a commercial policy for your business. The primary would be $1 million typically, or $2 million. And if you say, well, I want to have $5 million, then your insurance agent can go out and help that contractor find another $3 million. So if you're asking that they carry $5 million in a high risk contract, they may have multiple carriers. They may have one that's primary for $2 million. They may have an umbrella or an excess carrier that sits above the primary for the other $3 million. Does that make sense?
I think so. So minimum recommended numbers are going to increase from 2 mil, 1 mil to 3 mil, 2 mil. Does that make sense, John? I hope I'm reading that right.
Let me just add one thing to what you just said while John's answering. So
Okay.
the minimum limits that we recommend in the insurance, in our boilerplate, in what we just talked about, is $1 million, $2 million for liability. $1 million per occurrence, $2 million aggregate. The limits you actually require are going to be higher or lower, depending on risk. We ask that you require a minimum of $1 million, $2 million, but there may be situations where they won't pay $1 million, or it's a contract buster. There's no other bidders, and the only one you can get says, I'm not going to get $1 million. I'll go with 300,000. Then that may be what you have to settle for, because there's a lower risk and you have limited participation in your RFPs. So there's that, but the minimum would be $1 million, $2 million. You don't want to go out willy-nilly and start asking for a bunch of higher limits unless there's certainly risk involved in the type of contract that you're brokering with independent contractors. So $1 million, $2 million minimum. Higher risk may require that you want them to carry $2 million, $5 million, or $5 million, $10 million. And it's up to them to find the coverage. Their insurance agents are paid to do that. They have to go out and find the excess carriers, the umbrella insurance carriers, to get you the limit that you require. Just keep in mind that framework that I showed you, that determine the level of risk, minimum of $1 million, $2 million. There may be some where you're going to require a higher limit and some when you require a lower limit. And I just can't give you a hard, fast rule because contracts vary so greatly by your agencies and they're all different.
That's a great point. It's all about assessing that risk, as you discussed.
Do your best.
Yeah.
Do your best, and don't worry that you're going to get in trouble. Do your best. Would love to see indemnity provisions, better indemnity provisions in contracts, and better insurance requirements, including additional insured things. We've given you some basic things to get you started and to help you. If you're not where you need to be, then my thought would be do better. Take a step forward and make your contracts better than they are now. Make them better every day, and work with leadership, legal counsel, and or whoever to tighten them up if you can, because we have had a number of situations where, because we had the appropriate contractual insurance and indemnity provisions, it saved us millions of dollars. In another session, I could give you some examples. Looks like our time is running short today.
It is. This has been so valuable and interesting. So I just want to thank you so much for taking the time out. I'm sure everyone in here says a big thank you, and thank you for these resources.
Best wishes,
And
good luck, and I appreciate the invitation.
yay! All right, well, I'll get this video out for all y'all and I'll share it. And thank you so much, everybody.
Thank you.
Thank you.